We're going to talk last will and testaments, Nicholas, as opposed to what the first will and testament. First of all, why do they call it the last will and testament? Do you know?
Well, it's intended to be the last wishes of that person.
Okay.
So the last will, what are they willing? And then testament, that this has been decreed by me and witnessed, and there's a testament to these are my wishes.
Okay, well now we got that settled up. So how can you help folks who are looking to get their will, last will and testament done?
Yes, well, when it comes to last will and testament, this is really the only document that is required to be given to the court. Everything else remains private, which again, privacy is very important. And for some clients, they want a more robust estate plan, including a trust, to keep things private, to keep things out of the probate court. Where other clients, it's more simple family situation and simple assets. And as a result, the last will and testament is perfect. And it becomes the document that clearly outlines, my daughter is getting this, my son is getting this, this is the house, this is the retirement account, that's it. Everything else pours into the estate, which usually means furniture and clothes and random collectibles and memories. And so the executor, which is the person in charge of the will, the administrator, the person who administers the will, is then the one that goes to court and says, I am the executor, the will says it, I'm in charge of organizing all the assets and dispersing it if maybe there's two siblings, so me and my two siblings. And it's that simple, and that's what the will is designed to do.
Who is the executor? Is it somebody they pick, or is it just happens to be you? I mean, usually their lawyer that takes care of it.
Well, usually we advise loved ones.
Okay.
And so usually it's a child, sometimes a sibling, sometimes a grandchild, depending. And on occasion, the clients do ask that we act as the professional executor or professional trustee in the case if they have a trust. And that's usually when the heirs, the person isn't feeling can handle it. Maybe the heirs are too young or too old or special needs, or maybe and we just had this recently where a client called us up and said, I just had to do this for my sister and it was a nightmare. I do not want my granddaughter doing this. Will you please do it when I'm gone? Yes, we're absolutely able to help. And so when she graduates to heaven, we'll be in charge of that estate, organizing everything, paying all the final bills, and then making the disbursements according to the client's wishes.
What happens if somebody doesn't have a will? I mean, just to let folks know why you should get this done, what happens if they don't have a will?
What happens when a client doesn't have a will and they pass on, that's called being intestate. And that means without an estate. That means the government is now dictating what's going to happen. And we have Ohio law, the statutory law, saying this is exactly how the assets flow, period. And if you have a blended family, too bad. If you have children from different marriages, too bad. If all sorts of things that are more commonplace these days, too bad. And if you don't have a will, not only do you have to follow those statutory laws, now you have to go to a court, specifically the probate court. And you're dealing with the clerks of the court, you're dealing with the judge, and then also there's usually issues that can appear among the heirs, where let's say it's a sizable dollar amount, and Susie, the youngest daughter, hasn't seen mom in 25 years. And Frank, eldest son, has been caregiver for mom for the past 10 years, every single day, acting as an amazing son. Well, maybe mom didn't want the youngest daughter to get anything because she hasn't heard from him, and she wanted her eldest son to get the majority. It doesn't work like that. If you don't have your will, if you don't have the clear documentation, then everybody has a claim. And if there's a substantial amount of money, all of a sudden there's an ROI of, hey, it might cost $5,000, $10,000, $15,000 to sue my brother, but if I win, maybe I'm getting $500,000. And if I lose, It's a risk worth taking.
Plus, I can turn into a mess just for the relationship between the kids then, right?
Exactly.
Yeah,
and
that's
that
good
creates
enough.
a lot of infighting that sometimes is irreparable among the kids.
So it's my last will and testament, so it's done, or is there ever a reason that I would want to update my will later?
Yeah, that's a great question. Generally speaking, estate plans and wills and trusts, they can fail for two reasons. One, outdated. There you go. Number two, with the trust, not funded. You're not putting your assets in the trust. And when it comes to outdated, usually every 3, 5, 7 years, some life event happens. And we usually advise every 3 to 5 years to take a look, because usually there's an opportunity to make an amendment, make a modification.
Okay.
There could be births, there could be deaths, there could be marriages, there could be divorces, there could be homes sold, homes bought, businesses acquired, assets acquired, money moved, money changing hands. And so during these life events are usually when it's time to consider making a modification. And the modifications to the estate plans are very simple. It's the legwork, majority of legwork's done at the beginning to get the documents created. And 5 years later, minor tweak, my brother's no longer here, I want my son to be the executor. Easy. Another 5 years later, we sold our home and now we're living in this apartment. Easy. Another 5 years later, oh, we got 2 grandkids and we want to give each of them a couple $1,000s to put in their trust account so that they grow and can use it for college. And easy. And so keep it in mind when there's those life events, it's usually a good idea to consider updating your estate plan.
I'm curious, what would happen if, again, I'd moved to a different address, forgot to change my will, and I die? And I made it clear I want my home to go to my kid, but I had the wrong address in there. What happens?
Well,
what would happen?
If you haven't clearly defined which specific property you own in your estate planning documents, and then essentially that house that you now have is intestate. So it's as if you didn't have a will. It's like, oh, your will can govern these other things, but not the house. And so now you got to go to court. Now you got to show the death certificate. Now you got to show the deed. Now you got to show, ideally, the will shows intent, and it's up to a court to decide. The court might say, hey, I get it. You wanted your 2 kids, but you have 3 kids. So we're splitting up the house 3 ways, even if that third was meant to be disinherited. And there's all sorts of shapes and kind of forms of issues that can emerge when we don't specifically label the assets in our estate plan.